Imagine a globally recognized health charity operating inside a developing nation.
Okay.
And for a decade, they've been taking international donations, and they use that money to build this state-of-the-art hospital. They're providing free critical care to thousands of citizens.
Right, a massive community asset.
Exactly. Now imagine the local government just legally seizing that entire hospital, locking the doors, taking over the bank accounts, assuming control of all the medical equipment.
Swooping in and taking it.
Yeah, and imagine this happens not because the charity committed fraud, and not because they were caught laundering money, but simply because they missed a deadline on a bureaucratic registration renewal form.
Wow. Yeah, it sounds extreme when you frame it around a single hospital. But that scenario, that strikes at the very heart of this massive tension we are seeing worldwide right now.
And that's exactly what we're unpacking in today's deep dive. We're taking the research, the proposed laws, and all the geopolitical analysis from our sources to explore this critical modern friction point.
Which is really about how democracies are struggling to balance, legitimate national security concerns with the fundamental freedom of civil society.
Right. And the catalyst bringing this all to a head, and the primary focus of our sources today, is India's proposed 2026 amendment to the Foreign Contribution Regulation Act, or the FCRA.
Yeah, the FCRA. And to really grasp the gravity of India's proposed amendment, we have to sort of contextualize the era we're living in.
Which is complicated.
Very. For decades, the international community viewed philanthropy and foreign funding as this straightforward, morally pure endeavor.
Like empathy crossing borders.
Exactly. But today, governments are looking at that exact same pipeline of foreign money and seeing an entirely different picture.
Right.
They're seeing potential vulnerabilities, hidden agendas, threats to their own sovereignty. Because the nature of global conflict has evolved.
We're not just talking about traditional military threats anymore.
No, not at all. We are operating in an environment defined by information warfare, sophisticated influence campaigns, and just intense strategic competition.
So sovereign nations are basically asking this very uncomfortable question about international NGOs.
Right. They're asking, what happens when foreign capital is used not to build hospitals, but to subtly influence domestic political debates? Or stall strategic infrastructure projects.
Or shape public opinion. I was looking through our notes on this, and here's a practical way to conceptualize the anxiety these governments are feeling.
Okay, let's hear it.
Imagine you have a wealthy neighbor who constantly buys extravagant gifts for your kids.
Sure.
At first, you think it's just pure generosity, right? It's nice.
Free stuff.
Yeah. But over time, the gifts keep coming, the neighbor starts paying for summer camps you didn't approve of, and eventually, you start wondering if this person is deliberately trying to undermine your parenting.
I see where you're going with this.
You wonder if they're trying to, buy your kids' loyalty or turn them against you. And that creeping suspicion is essentially what nations are feeling right now about foreign-funded organizations operating inside their borders.
That's a really good analogy. The underlying fear is that foreign funding can be weaponized into a tool for domestic interference.
Right.
Governments are realizing that in the modern era, economic leverage and informational leverage are, they're practically indistinguishable from hard national security.
So for you listening right now, whether you actively follow international law, study geopolitics, or just want to understand how the invisible currents of global power impact local communities, this deep dive is going to map out that broader landscape.
Because we aren't just looking at India.
Exactly. We're starting with India's specific policy response, but we're using it as a lens to examine how the entire world is wrestling with this exact same wealthy neighbor problem.
And looking closely at the mechanics of India's FCRA provides the perfect entry point for this.
Because the FCRA isn't new, right?
No, not at all. The Foreign Contribution Regulation Act itself has been a fixture of Indian law since the 1970s.
Okay.
And from its inception, the act was never designed to be an outright ban or a blockade on foreign money entering the country.
It was always intended as more of an accounting and oversight mechanism. Like, if an organization wanted to receive foreign funds, they just had to register.
Right, register, maintain specific designated bank accounts, file detailed reports, submit to government audits, all that standard stuff.
And the stated objective was always to ensure that foreign contributions didn't negatively impact India's sovereignty or its democratic institutions.
Exactly. But our sources note a distinct historical trend here. With each major amendment over the decades, the regulatory dial has been turned tighter.
The oversight has become more stringent.
Much more. And the proposed 2026 amendment introduces a structural change that elevates the stakes from mere oversight to potential asset seizure.
Yeah, let's get into the mechanics of that change because the specifics are staggering.
They really are.
The 2026 amendment proposes establishing a designated authority.
Right.
And if an NGO loses its FCRA registration, this designated authority would be granted the legal power to step in and take control of any assets that were created using foreign contributions.
And the critical detail in the legislation, the part causing all the uproar, is the incredibly broad set of triggers for that asset seizure.
It's not just for criminal activity.
Far from it. The sources outline that the designated authority can intervene if an NGO's registration is officially canceled or suspended by the government. That part makes sense.
Sure.
But the power also extends to situations where registration is simply not renewed. It applies if an organization decides to voluntarily surrender their status.
Wait, really?
Yeah, it even applies if the organization just naturally ceases to exist.
Hold on. If we examine the administrative logic there, it seems like a massive overcorrection.
How so?
Well, I understand the government stepping in if a charity is actively funneling money to a militant group. But if the founders of, like, a grassroots educational nonprofit simply want to retire,
Right.
and they voluntarily wind down their operations and surrender their registration, this new authority could swoop in and seize the physical school building they constructed.
Under the proposed wording, yes.
I mean, the government is essentially equating a lapsed form with an active national security threat.
Well, the supporters of the 2026 amendment argue that this isn't an overcorrection at all, but rather the closing of a glaring regulatory loophole.
Okay, what's their angle?
Their perspective is strictly administrative. They argue that if a building or a bank account was built using foreign contributions, money that was permitted into the country, under the strict regulatory umbrella of the FCRA.
Right, it was regulated money.
Exactly. Then there must be a legal mechanism to manage that asset when the organization can no longer legally operate under that umbrella.
So the argument is that you can't have millions of dollars of previously regulated assets just, floating in a legal gray zone once the NGO dissolves.
Precisely. If the organization loses the legal right to receive foreign funds, the government argues it cannot allow the assets generated by those funds to remain unaccounted for or vulnerable to misuse.
That is the administrative justification.
Yeah. However, critics in our sources present a very different reality regarding how this power could actually be wielded.
The chilling effect.
A profound chilling effect. Critics argue that granting a designated authority the power to seize assets over administrative technicalities hands the government excessive sweeping control over civil society.
Because the threat is always hanging over them.
Exactly. The fear is that the mere threat of losing a headquarters or a hospital could be weaponized to silence dissenting voices.
Yeah.
Or coerce NGOs into aligning with state narratives.
Or punish organizations that advocate for environmental or human rights causes that complicate government projects.
Right. Because if the penalty for an administrative misstep is losing the entire physical infrastructure of your organization, NGOs are going to spend more time worrying about compliance than they do about their actual missions.
Which raises a crucial question for our deep dive. Is India's proposed mechanism an outlier? If we look at the global spectrum of how governments regulate foreign funding, where does this kind of asset seizure sit?
To understand the global baseline, it's really helpful to first examine the extreme restrictive end of the spectrum.
Where unchecked state control is the standard.
Right. If we want to see what an environment devoid of civil society protections looks like, we look at models operating in places like Russia and China.
Okay, let's break down the mechanics of the Russian model first. They utilize those infamous foreign agent laws.
They do. And under the Russian system, any organization or even an individual that receives foreign support and engages in what the state broadly defines as political activities is mandated to register as a foreign agent.
And I'm guessing that definition is pretty loose.
Oh, the definition of political activity is notoriously expansive. It often encompasses standard public advocacy, environmental reporting, human rights monitoring.
And the label itself, foreign agent, that carries an immense amount of historical and social baggage.
It's devastating.
It instantly delegitimizes the organization in the eyes of the public. It brands them as spies or traitors.
And beyond the stigma, the bureaucratic mechanics are designed to paralyze.
Yeah.
Organizations branded with this label face suffocating reporting requirements.
Just endless paperwork.
Endless. They're subjected to endless unannounced state inspections. They must meticulously label every single piece of content they produce, every social media post, with a disclaimer that it was produced by a foreign agent.
Wow. And the state framing is that this protects sovereignty.
Right. The state claims these rigorous measures are vital to protect Russian sovereignty from Western interference. But the reality highlighted by international observers is that the system is a deliberate mechanism to exhaust, bankrupt, and ultimately crush independent civil society.
Through administrative warfare.
Exactly.
Okay, so if Russia relies on administrative paralysis, how does the framework function in China?
China operates on a model of direct, pervasive supervision. In the Chinese system, foreign NGOs simply cannot operate independently.
At all.
No. They are required to find a state-backed sponsor and operate strictly within government-approved frameworks.
So the state is in the room from day one.
The authorities maintain sweeping powers to intervene at any moment. They can suspend operations, restrict specific activities, freeze bank accounts, and detain personnel.
Without the procedural hurdles found in Western democracies.
None of them.
And the justification there isn't just national security, right? It's also social stability, which is an incredibly elastic term.
Highly elastic. I mean, any labor organizing, any unauthorized legal advocacy can be interpreted as a threat to social stability. And that triggers immediate state intervention.
Wow.
State control is unapologetically prioritized over organizational independence.
So synthesizing those two approaches, it's less about a regulatory framework and more like operating a franchise where the local government is the ultimate landlord.
That's a great way to put it.
And this landlord holds the legal right to walk in, demand your internal communications, freeze your operating accounts, and permanently lock your doors on a Tuesday afternoon simply because your advocacy work doesn't align with their current 5-year plan.
That captures the dynamic perfectly. It is a system of constant supervision backed by the threat of immediate unilateral intervention.
Right.
But as we pivot back to analyzing India's 2026 amendment, our sources emphasize a really vital distinction.
Okay.
While the powers proposed in the FCRA amendment are undeniably vast, India is not an authoritarian state.
Right. India operates as a constitutional democracy.
Exactly. The laws actually have to survive judicial scrutiny.
That is the defining difference, isn't it?
It is. In India, there's an independent judiciary and a robust constitutional framework. Any action taken by a designated authority to seize an asset can be challenged, delayed, and theoretically overturned in open court.
So there's pushback.
Yes. That sets up a vastly different legal reality for how these powers are actually tested and applied, especially compared to the unchecked models of Russia or China.
Okay, so if the authoritarian systems represent the absolute ceiling of state intervention, let's explore the alternative. How do Western democracies approach this exact same fear of geopolitical influence and information warfare?
Because the anxiety isn't unique to developing nations.
Right. The US and Europe are just as paranoid about foreign interference.
They absolutely are. But the Western approach generally anchors itself on a completely different philosophy.
Which is?
Transparency and disclosure. If we look at the United States, the cornerstone legislation is FCRA, the Foreign Agents Registration Act.
Right,
FCRA was originally enacted prior to World War II to expose Nazi propaganda, but today it is a primary tool used to monitor foreign lobbying and influence operations.
And the mechanics of FCRA are fundamentally different from an asset seizure model. It's effectively a public registry system.
Exactly.
Like if a think tank, a PR firm, or an individual is operating in a political capacity on behalf of a foreign principal, they are legally required to publicly disclose that relationship.
They have to file their contracts with the Department of Justice, submit their financial records.
And the operative theory behind the U.S. model is that sunlight is the best disinfectant.
That's the phrase, yes. It assumes that if the public knows exactly who is funding a particular policy white paper or a media campaign, they can properly evaluate the bias and credibility of that information.
So the government's role is to ensure the label is accurate, not to control the speech or seize the infrastructure of the organization producing it.
Right.
So unless a foreign-funded think tank in Washington, D.C. is actively engaged in money laundering, wire fraud, violating international sanctions, or financing terrorism, the U.S. government isn't going to seize their office building just because their foreign funding contract expired.
Generally speaking, no. Seizing private property or dismantling an organization in the U.S. requires proving actual criminal conduct or severe regulatory breaches.
usually following extensive due process.
Exactly. This reflects deep-seated constitutional protections for private property rights and the First Amendment freedom of association.
And the sources indicate that other Western nations operate on a similar frequency. Countries like Australia and the United Kingdom occupy what we might call a middle ground.
Yeah, the UK recently implemented its foreign influence registration scheme, and Australia has its own foreign relations legislation.
Okay.
They acutely recognize the sophisticated threat of modern foreign influence. They possess robust enforcement mechanisms and independent oversight bodies.
But like the US, their systems rely heavily on mandatory disclosure.
Yes, ongoing regulatory supervision and public accountability, rather than defaulting to the outright state control of physical assets.
Okay, here is where I have to push back on that transparency first model, though.
All right, let's hear it.
If we evaluate this through the lens of modern digital information warfare, doesn't the Western reliance on disclosure leave those countries incredibly vulnerable?
How so? What do you mean?
Well, the transparency model assumes a rational, well-informed public that carefully reads the fine print before consuming information.
Sure.
But influence operations today don't work like that. If an adversary state decides to funnel tens of millions of dollars into domestic shell organizations to fund sophisticated astroturfing campaigns.
Like flooding social media with polarizing content.
Yes, artificially amplifying divisive domestic issues, organizing protests to stall critical infrastructure, transparency doesn't neutralize that threat.
Because the content is already out there.
Right. Even if the Department of Justice eventually forces those organizations to file a FCRA disclosure, the chaos has already been injected into the public bloodstream.
I see your point.
The goal of the adversary isn't to win a rational debate. The goal is chaos. And transparency just puts a name tag on the chaos.
That is a very sharp observation. And the vulnerability you just described is precisely the criticism leveled against the Western model by national security experts globally. Merely slapping a disclosure label on a highly sophisticated algorithmic influence campaign is often entirely insufficient to protect a nation's strategic interests.
Because the damage is done at the speed of the internet.
While the legal disclosures move at the speed of bureaucracy.
Wow. Yeah.
And that perceived inadequacy of the transparency model is exactly why sovereign nations like India are actively engineering stronger, more direct, and admittedly blunter instruments.
Like the ability to immediately seize the assets of organizations they deem compromised.
Exactly. Which brings us full circle to the ultimate battleground for India's 2026 amendment.
Right, because we've mapped the extremes now, from the landlord-style intervention in authoritarian states to the highly vulnerable transparency registries in the West.
Yes.
So how does a massive modern democracy actually resolve the tension between those two polarities?
It resolves it by moving from the realm of political rhetorics into the rigorous arena of constitutional law.
Right.
The true test for India's proposed FCRA amendment won't be settled in press conferences or diplomatic summits. It's going to be fought line by line in the constitutional courts.
What are the specific legal doctrines that will dictate that battle? Like, what are the judges actually going to be weighing when a designated authority tries to seize a hospital?
The sources highlight several foundational constitutional provisions that are inevitably going to collide here. The first is the fundamental freedom of association.
Okay.
The courts will have to determine if a vibrant, independent civil society can even exist if the sort of asset seizure is constantly hanging over every administrative filing.
And there is also the issue of property rights, specifically under Article 300A of the Indian Constitution.
Right.
Because taking over a headquarters or freezing a massive endowment is, at its core, a deprivation of property.
Yes, and Article 300A mandates that no person shall be deprived of their property save by authority of law. Now, while it's not an absolute fundamental right in the same category as the right to life, it requires the state to prove that its actions are not arbitrary.
So the courts will employ a proportionality test.
Exactly, they'll ask, is the permanent seizure of a multi-million-dollar asset a proportionate legal response to an NGO failing to renew a registration form on time?
That seems like a massive hurdle for the government to clear. It touches on the broader legal principles of natural justice and due process.
Definitely.
If this designated authority is going to execute these seizures, what is the appellate process? Are organizations given a fair hearing, or is the seizure unilateral and immediate?
The answers to those procedural questions will ultimately determine if the law stands. And this synthesizes the core realization of our entire deep dive today.
Which is?
If we look at the global trajectory, the era of the pure, unquestioned charitable transaction is completely over. Almost every nation on Earth now regulates foreign funding. That is a universal, established reality.
So the debate isn't about whether regulation should exist.
Oh, no, not at all. The defining question of our era is whether the specific powers a government grants itself to enforce those regulations are proportionate to the actual threat.
Are the mechanisms transparent?
Exactly. And crucially, are they subject to rigorous, independent legal safeguards that prevent those powers from mutating into tools for domestic political suppression?
And for you listening to this is exactly why these dry administrative laws matter deeply, even if you never interact with an NGO and even if you don't live anywhere near India.
Right, because it's a blueprint.
What we're analyzing today is a live, real-time stress test of modern democratic architecture. It is the story of how your government, wherever you happen to be, is attempting to balance its very real, very urgent need to protect its national sovereignty from sophisticated outside influence.
Against your fundamental liberty to associate, to organize, and to own property without fear of arbitrary state seizure.
This is a huge deal.
It is. And the public discourse surrounding these laws is almost always falsely polarized into a strict binary. Politicians frame it as a stark choice. You are either prioritizing robust national security or you're defending civil society freedom.
It's framed as a zero-sum game where you have to pick a team.
But the reality detailed across all of our sources is that this is a false choice. It's a highly complex, incredibly delicate balancing act that every major country is currently struggling to navigate.
Yeah.
India's proposed FCRA Amendment Bill 2026 is simply the latest, most visible, and highly consequential chapter in a much larger global narrative about how we preserve democratic values in an environment where foreign influence is pervasive and constantly evolving.
It really provides a fascinating, if somewhat unsettling lens through which to view international relations. We are watching the rules of the game being rewritten in real time.
We really are. And to leave you with a final thought that builds on everything we've discussed regarding information warfare and asset seizure.
Oh.
Consider the trajectory of where this is heading. Throughout this deep dive, we have been primarily discussing the government seizure of physical assets, a designated authority taking over a brick-and-mortar clinic, locking an office building, or freezing a traditional bank account.
Tangible physical infrastructure.
Right. But if foreign influence and information campaigns are now truly treated by sovereign states as a national security threat on par with physical warfare, how long before foreign-funded digital assets become the next major frontier for government seizure?
Oh, wow. That is a terrifying logical next step.
If a modern advocacy organization loses its legal registration under these strict new laws, could a government authority legally seize its proprietary digital networks?
Jeez.
Could the state demand the handover of their encrypted communication channels, their massive social media accounts, or the proprietary demographic data they have collected on vulnerable citizen populations?
Right, because in an era defined by data and digital influence, an NGO's server architecture and follower lists might be infinitely more valuable and infinitely more dangerous in the wrong hands than the physical office building they rent.
Exactly. It completely reframes the scale of the threat.
You start out worrying about the wealthy neighbor buying your kids physical toys, and suddenly you realize the real danger is that they've quietly gained admin access to the entire family's digital lives. It is a wild, complex frontier.
It really is.
Well, that brings us to the end of today's deep dive into our sources. We hope this exploration provided you with the context to see beyond the political rhetoric and understand the intricate mechanics driving these global shifts. As always, we encourage you to question your assumptions, look for the underlying why in the news you consume, and stay fiercely curious. Thanks for listening.
Subscribe to Ambat Legal Insight and stay legally informed with clear, practical, and reliable breakdowns of the law. Follow our channel and activate the bell icon so you never miss important legal updates, case analyses, and expert insights that matter to every citizen. Support our mission of spreading legal awareness by liking, sharing, and commenting, because your one action can help thousands become more legally empowered. Join the ALI community today across YouTube, podcast, and social platforms and take a step toward understanding your rights, your laws, and your justice. Ambat Legal Insight, because law is for everyone.